as a presidential candidate. Article 137, subarticle B, carves out exemptions for the sitting president, the deputy president, and members of parliament. Cabinet secretaries are not included in that exception. Article 148, subarticle 1 also locks the qualifications of a deputy president candidate to those of a presidential candidate under Article 137. And Article 148, subarticle 2 provides that there shall be no separate nomination process for the deputy president at a general election. Article 149, subarticle 1, however, creates an entirely distinct pathway of filling a mid-term vacancy, as we have already observed, through a direct presidential nomination followed by a National Assembly vote. It makes no cross-reference to the electoral machinery or disqualification timelines that apply under Articles 137 and 148 in the general election context. A strict textual reading of Article 148, subarticle 1 and Article 137, subarticle 2b together would, if applied without contextual qualifications, bar an active cabinet secretary from nomination unless a timely resignation had occurred. However, we are satisfied that Article 149, subarticle 1, creates a sui generis process that cannot be evaluated by mechanical application of the general election framework. Article 149, subarticle 1, omits the standard electoral requirements, including the signature collection requirement, and Article 137, subarticle 1d, which signals the framers' intention that this provision operates independently of the general election machinery. To apply the strict disqualification timelines of the electoral context to a sudden or unforeseen midterm vacancy would risk creating an executive leadership vacuum of precisely the kind that Article 149, subarticle 1 was designed to prevent. In any event, we are satisfied that the factual premise of the petitioner's challenge is not established on the evidence. The primary constitutional mischief targeted by Article 137, subarticle 2b, is the prevention of active public servants from deploying state resources or conflicting institutional mandates to influence an election or appointment. The evidence before this court establishes that despite the unique circumstances of his nomination, His Excellency Kindiki formally resigned from the cabinet and gazetted his exit prior to taking out of office as deputy president. By severing his ties to the cabinet before assuming the deputy presidential office, the potential conflict of interest under Article 137, subarticle 2b is designed to address was lawfully cured. The core integrity parameters of Chapter 6 and Article 137 of the Constitution were accordingly satisfied. This ground of challenge therefore fails. Before concluding on this issue, we must address whether the speed with which the state resolution, with which the Senate resolution was gazetted, the President nominated Professor His Excellency Kindiki, and the National Assembly approved the nominee, contravened the Constitution and the law. The petitioners argued that the extraordinary haste following the Senate's resolution of 17th of October 2024 revealed a predetermined impeachment process. In their view, the immediate gazettement, swift presidential nomination, and expedited parliamentary approval were evidence of a pre-arranged outcome. They contended that such speed undermined constitutional values of transparency, accountability, public participation, fairness, and constitutionalism. The respondents, including His Excellency Kindiki, took the opposite position. They maintained that the Constitution itself anticipates expedition in matters concerning high constitutional office. Once a vacancy arose in the office of the deputy president, they argued the president was constitutionally bound to act under Article 149. Prompt compliance with such a duty, they insisted, cannot be itself amount to constitutional impropriety. Turning to the Constitution, Article 149(1) we have already reproduced that section, that article. I don't need to go through it again. Proceed. This provision leaves no doubt that the framers of our constitution deliberately contemplated speed in filling in a vacancy of the deputy president's office. The rationale is evident, and it is to safeguard continuity and the stability in the national executive by requiring prompt action. Judicial President reinforces this principle. In Ali Hassan Joho and another versus Suleiman Said Shabal and others, this is a Supreme Court petition number 10 of 2013. The court held that constitutional timelines are substantive requirements, not procedural conveniences, and cannot be extended by legislation or judicial discretion. Similarly, in the Mankin Aramat versus Harun Meitamei, Lenpaka, and two others, the Supreme Court, it's a Supreme Court matter petition. The court emphasized that constitutional timelines are binding commands, cautioning against reliance on Article 159 to circumvent them. The same principle was affirmed in Moses Masika Wetangula versus Muskari Kombo, Muskari Nazi Kombo, and two others, and in Harun Meitamei Lempaka versus Lempakian Aramat, where the Court of Appeal underscored the constitutional significance of timelines. Collectively, these authorities highlight that timelines serve vital public interests, including certainty, legitimacy, and orderly governance. The Supreme Court's decision in Raila Odinga and 5 others versus Independent Electoral and Boundaries Commission and 3 others, this is presidential petition number 5 of 2013, is also instructive. Addressing timelines under Article 140, the court had the following to say, and I quote, according to Article 140 of the Constitution, it is clear that in the resolution of presidential election disputes, I repeat that. According to Article 140 of the Constitution, it is clear that expedition in the resolution of presidential election disputes is of essence. End of quote. The court warned that prolonged uncertainty regarding the presidency undermines public interest. This reasoning reflects a broader constitutional philosophy that uncertainty in the occupants of high office is detrimental, and the Constitution deliberately establishes mechanisms to ensure continuity. Applying these principles, we are not persuaded that the prompt gazettement of the Senate resolution was unconstitutional. Once the Senate concluded its process, the deputy president ceased to hold office, and nothing in the Constitution required a waiting period before gazettement. Likewise, the president cannot be faulted for acting swiftly under Article 149. He was constitutionally obligated to nominate a replacement within 14 days. Compliance with this duty cannot be construed as wrongdoing. To hold otherwise would penalize constitutional actors for fulfilling their obligations. The same reasoning applies to the National Assembly. Article 149 allows up to 60 days to vote on a nomination, but it does not require Parliament to exhaust that period. Acting sooner than the deadline is not evidence of illegality. Speed alone does not establish predetermination. The law requires objective proof that a decision maker had closed their minds before exercising power. Mere expedition does not meet that threshold. We therefore find that the gazettement of the Senate resolution, the president nomination of His Excellency Kindiki, and the nomination National Assembly's approval did not contravene the Constitution simply because they were undertaken expeditiously.